Welcome to LexTalks Legal Topics Simplified, where we like to break down some of those really complex legal concepts and make the law a little bit easier to understand one concept at a time. And today we're diving into the world of international commercial arbitration, or ICA, as it's more commonly known.
Ah, ICA.
It's a topic that's becoming more and more important, especially for those of you out there who are interested in or involved in Indian legal studies.
Absolutely, it really is. As India's role in the global marketplace continues to grow, we're seeing a lot more cross-border business transactions. And, well, naturally, with more business comes more disputes, right?
Makes sense. So let's start with the basics. What exactly is ICA, and why is it such a popular choice when it comes to resolving these international disagreements?
Okay, so imagine this. You have an Indian tech startup, and they're in a contract dispute with a big U.S. corporation. Now, if they were to go through the traditional court system in either country, it could be a real nightmare. You've got different legal systems, potential language barriers, and the whole process could drag on for years,
Years.
costing a fortune in legal fees.
That sounds really daunting,
Ye-
especially for a smaller company.
Exactly. And that's precisely where ICA comes in. It's essentially a private process where both parties agree to have their dispute decided by a neutral third party or an arbitrator instead of going through the whole court system.
So it's like having a private judge just for your specific case.
You got it. That's a great way
But
to think about it. And one of the biggest advantages is that it levels the playing field for everyone involved. Neither party has that home court advantage, so to speak. And the process is designed to be fair and impartial regardless of where the parties are from or where the actual dispute took place.
I can see how that would be appealing, especially when you're dealing with different countries and legal systems. But what about enforcing the arbitrator's decision? Is that as straightforward as a typical court judgment?
That's a really important question, and it's actually one of the main reasons why ICA is so effective. There's an international treaty called the New York Convention, and it makes arbitral awards enforceable in over 160 countries, including India. So if one party decides not to comply with the decision, the other party can go to a court in any of those countries to have it enforced.
That's reassuring. It
Yeah.
gives the whole process some real weight.
It does. And there are a few other advantages worth mentioning. For one, ICA is usually much faster and a lot more flexible than traditional litigation. The parties can actually tailor the process to fit their specific needs, like choosing arbitrators who have expertise in their particular industry. They can set their own timetable and even decide on the language and the rules of procedure for the whole thing.
So it's a lot more control compared to the traditional court system where you're kind of at the mercy of the court schedule and their procedures.
Exactly. And another big plus for a lot of businesses is the confidentiality. Court proceedings are often public, which can be a problem if you're dealing with sensitive business information. But with ICA, everything is kept private, which helps protect trade secrets and reputations.
So we've got neutrality, enforceability, speed, flexibility, and confidentiality. It's starting to sound like ICA is the perfect solution for international disputes. But I have a feeling there might be some downsides too, right?
Well, you're right, there are some potential drawbacks to keep in mind. One concern is that there's always a potential for bias, even with the careful selection process for arbitrators. It's not always guaranteed.
So that neutrality, even though it's a major selling point, isn't always a sure thing.
It's something to be aware of. And you also have to be very careful when you're drafting the arbitration agreement, especially if there are multiple parties involved. A poorly drafted agreement can lead to a lot of confusion and delays down the road.
That sounds like it could get messy really quickly.
Oh, it can. And while confidentiality is generally a good thing, there are situations where it might be a problem. For example, if the dispute involves allegations of fraud or misconduct that could have a wider impact, there might be some pressure to make those proceedings more transparent.
So those safeguards, while they're valuable, aren't always absolute. It sounds like it's really important to go into ICA with a realistic understanding of both its strengths and its limitations.
I completely agree. But even with these potential drawbacks, ICA is still a powerful tool for resolving international commercial disputes. And understanding how it works is becoming more and more important for anyone who's involved in the global marketplace.
Absolutely. But before we go any further, let's zoom in on how ICA specifically plays out in India.
Okay, great idea.
Because the legal framework in India obviously plays a really big role in shaping how ICA functions for both Indian businesses and their international partners.
Oh, absolutely.
Yeah.
It does. And there's one more thing I wanted to mention before we move on. Despite its popularity, ICA has actually received some criticism, particularly from those who think it might be biased towards Western commercial interests. It's a complex issue with historical roots and definitely something to keep in mind as we explore ICA in the Indian context.
That's a really interesting point and definitely something worth thinking about. We'll be sure to revisit that a little bit later in our discussion. But first, let's take a closer look at how the Indian legal system approaches this whole fascinating field of ICA. Okay, so we've talked about the pros and cons of ICA in general, but now let's shift our focus to India. What makes the Indian system unique when it comes to international commercial arbitration?
Well, in India, we have the Arbitration and Conciliation Act of 1996. It's often referred to as just the 1996 Act. And this act lays down the groundwork for both domestic and international commercial arbitration in the country.
So it's kind of like our rule book for all things arbitration.
Exactly.
Huh.
And it's split into two parts. Part one deals with situations where the arbitration takes place within India. It outlines the procedures and the guidelines. And then part two focuses on enforcing those foreign awards, the awards that are given in other countries.
Ah, so it covers both sides of the coin. Arbitrating here in India, and then also dealing with those decisions that are made elsewhere.
Exactly. And this actually leads to another interesting point. India's 1996 Act is significantly based on the UNCITRAL model law and rules of 1976. It's kind of like a globally recognized blueprint for arbitration procedures.
So by aligning with this model law, India's basically saying we want to be a part of a more standardized global approach to arbitration.
That's a great way to put it. This harmonization helps create a more predictable and consistent framework for all those international businesses that are operating in India.
That makes a lot of sense. Now, you mentioned enforcing foreign awards. How does that actually work in practice in India?
Well, remember we talked about the New York Convention. India is a signatory to that treaty, and that's crucial here. It means that an arbitral award from another country that's also part of the convention can be enforced right here in India.
So it's kind of like a legal fast track for those decisions to be recognized and upheld here.
Mm.
But is it really that simple?
Well, there's a process, of course. It involves filing something called an execution petition. It's a formal request to enforce the award with an Indian court. And then the court examines the award to make sure it meets all the requirements of our 1996 Act.
I see. So there's a check to make sure everything's in order.
Yeah.
What happens if it passes that scrutiny?
If the court is satisfied, the foreign award is then treated as if it were a judgment from an Indian court, which means it can be enforced just like any other court order.
Interesting. So it's not just automatically rubber stamped, but it does have a very clear pathway to become legally binding in India.
Yeah, absolutely. And that really shows India's commitment to uphold its international treaty obligations and provide a reliable framework for international commercial arbitration.
Now, speaking of the Indian framework, are there any specific nuances or things to watch out for when it comes to ICA in India?
Yes, there are a few. For example, if a party wants to challenge an arbitral award, there's a specific section in the 1996 Act, Section 34, and it lays out the grounds for challenging and the procedure involved.
Sounds important. What's the catch?
Well, you only have 3 months from receiving the award to file a challenge. After that, you're generally out of luck.
3 months.
Yeah,
That's a tight deadline. So acting quickly is key if you disagree with the outcome.
exactly. Another point to remember is that India's ICA landscape is constantly evolving, thanks to recent Supreme Court judgments and amendments to the 1996 Act itself.
That makes sense, given how dynamic the field of international business is. Can you give us a few examples of some of those judgments and how they've shaped the system?
Absolutely. So one landmark judgment really clarified the concept of the seat of arbitration. It stated that the place where the arbitration actually happens is essentially equivalent to the legal seat, which then determines which court has jurisdiction and which laws apply.
So it kind of cleared up a potentially confusing distinction, but one that could have huge implications.
Exactly. Another important ruling affirmed that even allegations of fraud can be addressed through arbitration, which basically widens the scope of what can be handled through ICA.
So it's not just for straightforward contract disputes anymore. Are there any other significant trends that we should be aware of?
Definitely. There's a growing emphasis on appointing arbitrators who are truly independent and impartial. The Supreme Court has made it very clear that even a hint of bias can really undermine the entire process.
Right, because that neutrality is the foundation of the entire system.
Exactly. And there have also been key decisions upholding the enforceability of emergency arbitrator awards.
Hold on, emergency arbitrator awards, what are those?
They're a relatively new tool, but it allows parties to seek urgent interim relief, like stopping a potentially damaging action before a full tribunal is even formed.
So it's kind of like a safety valve when time is really of the essence. I can imagine that could be crucial in certain situations.
Absolutely. And speaking of crucial details, there was a fascinating judgment related to stamp duty, which, as you know, is a big deal for legal documents in India.
Oh yes, it's essential for making agreements legally valid. What was so fascinating about this judgment?
Well, it stated that even if an agreement containing an arbitration clause isn't properly stamped initially, it can still be considered valid as long as it's rectified later by the relevant authorities.
So even a technicality like that won't necessarily derail the entire agreement.
Precisely. It shows how India's ICA system is adapting to make dispute resolution more efficient and fair.
It sounds like India's really making strides in creating a robust and supportive environment for ICA. But I'm sure there are still some challenges and some areas where things could be improved, right?
Of course. It's a dynamic field, always evolving, and with that evolution comes new hurdles to overcome.
Right, well, let's tackle those challenges head on in our next segment. All right, so we've talked about the good and the bad when it comes to ICA in India and how the system actually works. But as with any legal framework, there are always those areas that spark debate and call for some improvement. So what are some of the challenges that legal experts are talking about right now when it comes to ICA in India?
Well, one of the big things is the 2019 Amendment Act. It introduced a fixed time frame for parties to file their claims and defenses. Now, while that could streamline things for simpler cases, it could actually create problems in more complex disputes.
I see what you mean. Because if you're dealing with a really complicated issue where you need a lot of time to investigate and gather evidence, having a strict timeline could really tie your hands.
Exactly. And another issue is the ambiguity around the confidentiality clause. There aren't any clear exceptions, and that's causing some practical concerns. Especially when you think about interactions with experts or third-party funders, they might need access to certain information to effectively do their jobs, but the confidentiality rules make that tricky.
Right, so that confidentiality, which we said was a big advantage of ICA, well, it's not always as simple as it seems.
Exactly. And then there's the growing role of arbitral institutions in India. While their presence is increasing, there are still some questions about the accreditation process and whether it's creating unnecessary delays.
So even though institutions are becoming more important, there are still some kinks to work out in terms of making sure everything runs smoothly. So what are some of the potential solutions that people are talking about?
Well, the Supreme Court has been pretty active in trying to address some of these concerns. They've said that we need a faster and more efficient way to appoint arbitrators to avoid those unnecessary holdups. And they've also suggested a shorter limitation period for challenging those appointments, just to streamline things a bit more.
So it sounds like a lot of it comes down to finding that balance between fairness and efficiency and making sure the system keeps up with the demands of the business world.
Exactly.
Well, that brings our deep dive into ICA in India to a close. I feel like we've covered a lot of ground today.
Me too. It's been a really interesting discussion.
What was the most interesting part for you?
I think it's fascinating how India is working to make sure its ICA system is in line with international standards, but at the same time, it's adapting to fit the specific needs of the Indian legal and business landscape.
I agree. It's a delicate balance, but it seems like they're doing a pretty good job. Now, before we go, I want to leave our listeners with something to think about. Given how quickly India's economy is growing and its expanding role in global trade, how do you see ICA in India evolving in the future? How can it best serve the interests of both Indian businesses and their international partners? It's definitely something to consider as we continue to watch this field develop. And with that, we'll wrap up another episode of Lex Talks. Thanks for joining us, and don't forget to subscribe so you can keep learning about the legal world with us.